John, if you will, kind of break it down for us, because like I was saying, I understand that when a railroad worker is injured on the job, the law that they follow is different than someone that's injured at another workplace.
Sure, and that's kind of the point of why we're here tonight, is that it is a unique situation. Most people are used to a typical workers' compensation situation where if they're hurt at work, they are entitled to recover certain amounts of monies, no matter whose fault it is, whether their employer did something wrong or whether they did something wrong. The railroad is different, and it actually started well before what we now know as workers' compensation, and you have to show that the railroad actually did something wrong in order to recover for an on-the-job injury for a rail worker. So it's very important.
The federal law, though, is known as the FELA, Federal Employers Liability Act.
Right, you got it.
So explain a little bit about, if people are not familiar with that, because I'm certainly not. So explain just a little bit about that.
Because of the unique nature of rail work, that is, you're moving cars, you're moving things across state lines, Congress enacted a very special statute called the Federal Employers Liability Act, FELA, that we call it, F-E-L-A. And this protects rail workers who are hurt at work. And it's important because they are in a dangerous work environment, and it's very important to protect them and their safety, for them and their families, obviously.